Burks. In case 2500357, People State of Michigan versus Desmond Burks. That matters before the court for a motion hearing. Will the parties please state their appearances for the record?
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan, P number 39570.
Good morning, Your Honor. Mike Glenn for the people. My P number is 77516.
Good morning, Your Honor. Sarah Kraus, P81830, appearing on behalf of Desmond Burks.
And good morning, Your Honor. Gabby Silver, also appearing on behalf of Desmond Burks. You tell the judge your name, please.
Desmond Burks.
Thank you. Good morning, everyone. I was able to read both motions, the motion to quash as well as the response. There was a voluminous transcript, the preliminary examination. The court has been able to review that as well as the exhibits that were admitted and presented to this court. And so at this time, I am ready to hear arguments on this case. Go ahead, Ms. Krause.
Thank you, Judge. Would the court like me at the podium or at the table?
Whatever you prefer.
Judge, I just want to start by saying that the evidence at the preliminary examination does not establish that Mr. Burks killed Dr. Hoover intentionally, accidentally, or otherwise. The people's theory of this case is circumstantial at every turn. There are witnesses, several witnesses in this case, that the people are relying on to construct a chain of inferences that's simply too attenuated to support probable cause in this case. Several of the witnesses were granted immunity in this case. They admitted on the stand to destroying evidence in this case, burning clothes, disposing of the alleged weapon used, but received immunity for their cooperation, Judge. That directly impacts their credibility in this case. The credibility issues taken together with the other issues in this case render the bind over improper. I'm going to turn to the specific charges now. First-degree murder, as this court knows, requires premeditation and deliberation, and the prosecution failed to establish any of this during the preliminary examination. There's no evidence whatsoever in this case of a plan, motive, or deliberation. There's no communication suggesting intent, no statements, no preparations, and no actions before or after that support a deliberate killing in this case. The people attempted to infer premeditation here from the fact that Mr. Burks was allegedly seen with a handgun about a month before Dr. Hoover was killed, but mere possession of a firearm weeks earlier does not show intent to kill Dr. Hoover, nor does it show premeditation. Mr. Burks may have had contact with Dr. Hoover and was later linked to property allegedly belonging to him, and the prosecutor wants us to believe that Mr. Burks must have killed him based on that. That inference requires stacking speculation upon speculation in this case. At most, the evidence shows a relationship between the two men, but not an intentional or premeditated homicide. Without the evidence of motive, planning, or deliberate action, the charge of first-degree premeditated murder cannot stand. I secondly want to move to the felony murder count. The connection between the homicide and the other felony cannot be established through the testimony. The evidence shows from the preliminary examination that the CashApp transfers, the jewelry purchases, all occurred after Dr. Hoover's death. The felony murder doctrine only applies when the intent to steal exists at the time of the homicide. If the intent to steal was formed after, that's not felony murder, Judge. And this is precisely the case here. The prosecution's evidence suggests at most that after Dr. Hoover was deceased, someone used his accounts and property. There's no testimony, no record evidence, no forensic link showing Mr. Burks killed Dr. Hoover in order to commit a larceny. Even assuming that Mr. Burks later participated in the financial fraud, that conduct is legally distinct as occurring after the homicide. The required nexus for felony murder simply is not there. I would like to finish by saying, since these counts can't stand against Mr. Burks, neither can either of the felony firearm counts that he's charged with. I believe in this case, the magistrate who heard the preliminary examination evidence, that was mostly speculation and testimony from witnesses who were under immunity. And all of the exhibits, I believe the magistrate abused his discretion in binding Mr. Burks over on these charges. And I would ask the court to quash the information at this time.
Thank you.
Thank you.
Travis. Anything on behalf of the people?
Your Honor, the people are going to stand on their previously filed pleadings.
Okay, thank you. The district court has a duty to bind the defendant over to circuit court for trial if the court finds that a felony has been committed and probable cause that the defendant committed it. That's People v. Stone 463 Mich 558 2001. Probable cause exists where the court finds a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious person to believe that the defendant is guilty of the charged offense. That's People v. Orzam 224 Mich. App 551 1997, as well as People v. Regal 223 Mich. App 34 1997. Guilt beyond a reasonable doubt need not be proven at the preliminary examination. To justify a bind over, there must be some evidence from which each element of the charged offense may be inferred. If credible evidence conflicts and raises a reasonable doubt as to the defendant's guilt, then the issue of guilt still becomes a question of fact left to the trier of fact. That's People v. King 412 Mich. 145 1981. In making the determination as to whether the defendant should be bound over to circuit court, the examining magistrate must determine the weight and the competency of the evidence. Now, pursuant to People v. Henderson 282 Mich. App 307 2009, a district court's ruling that alleged conduct falls within the scope of a criminal law is a question of law that is reviewed de novo. But a decision to bind a defendant over on the factual sufficiency of the evidence is reviewed for an abuse of discretion. And when a circuit court reviews a bind-over decision pursuant to the Henderson case from a district court, it must consider the entire record of the preliminary examination and not substitute its judgment for that of the district court. The prosecution in this case, and in its motion, lays out the allegations and their theory of this case. And these are at this time only allegations. The investigation, based on the preliminary examination transcript this court read, began as a result of a complaint that a white Land Rover was blocking a driveway at 9901 Coyle Street in the city of Detroit. There was alleged blood in the interior of the vehicle. The vehicle belonged to Dr. Devon Hoover. Shortly thereafter, there was a wellness check at the home of Dr. Devon Hoover at 150 West Boston Boulevard in the city of Detroit. The driveway gate was open. There was blood near the back exterior entrance of the home. After a search of the home, Dr. Hoover was found in the third floor crawl space in the attic. An autopsy was conducted by Dr. Lee Lavity, in which she opined that the cause of death was 2 gunshot wounds to the head, and the manner of death was homicide. Now, at the preliminary examination, the prosecution presented evidence linking Mr. Burks to the homicide. Immediately after the homicide, evidence showed that the defendant siphoned off over $20,000 from Dr. Hoover's accounts and transferred that money to Mr. Burks' associates in CashApp accounts. Mr. Burks then told his associates to transfer all or some of the money back to him in his CashApp account. The allegations are that he coordinated with an associate to use Dr. Hoover's credit card. Now, evidence based on phone records and data and cell phone analysis was that he was going to meet, he being Mr. Burks, was going to meet up with Dr. Hoover on April 22nd of 2023, had a personal relationship with him. Circumstantial evidence allegedly shows he was with Dr. Cooper on or about the time of the homicide, and the defendant retained Dr. Hoover's phone. After the homicide had occurred, Mr. Burks was in possession of a large amount of money and indicated to one associate that he had enough money to buy a house. The evidence showed before this incident that the defendant had a very low income and lived in part off the money of other people. Now, the evidence admitted in the preliminary examination also shows that the defendant drove Dr. Hoover's Land Rover with blood inside the vehicle to 9901 Quayle Street on the day of the homicide. His actions after the homicide, it could be argued, and I know the prosecution is arguing this, can show a consciousness of guilt and a potential cover-up of the homicide, including getting rid of a handgun. He sought to himself and to other associates delete information on cell phones and to change phone numbers. Mr. Burks allegedly was in possession of Dr. Hoover's personal items and allegedly burned the clothes that he was wearing on the day of the homicide. Information also showed that the defendant immediately went to buy jewelry after the homicide at Fairlane Mall. There was a lot of other evidence introduced at the preliminary examination, including evidence that the prosecution uses to link Mr. Burks to Dr. Hoover's death. Now, with regards to the first count of homicide, murder in the first degree premeditated, to constitute first degree premeditated murder, it must be established that a defendant's intentional killing of another was deliberate and with premeditation. That's People v. Youngblood 165 Mish-App 381, 1988. While the length of time needed to measure and evaluate a choice before it is made is incapable of precise determination, there must be some interval in which a second look can be contemplated. That's People v. Furman 158 Mish-App 302, 1987. Premeditation and deliberation may be inferred from the facts and circumstances established on the record. People v. Gonzalez 178 Mish-App 526, 1989. Though not exclusive, the factors which may be considered to establish premeditation include the previous relationship between the defendant and the victim. And here there was a previous personal relationship between the two. A second factor is the defendant's actions before and after the crime. The court can take, certainly in a motion like this, the defendant's actions after the crime to show a premeditation to kill. And based on what the courts indicated and what was alleged, that can be enough based on the actions of the defendant immediately after the homicide to show potentially premeditation. A third aspect, a third factor, is the circumstance of the killing itself, including the weapons used and the location of the wounds inflicted. These are 2 gunshot wounds to the head. There is enough evidence to go forward on count 1. With regards to counts 2 and 3, larceny, $20,000 or more is count 3, and homicide, felony murder is count 2. The allegations are that, for instance, there was a Range Rover SUV, keys that were taken, a cell phone that was taken, cash, credit cards, financial devices by Mr. Burks from Dr. Hoover. And the evidence does indicate it was $20,000 or more, and that would be a predicate of the underlying felony for count 2. So there is enough evidence to go to trial on that count as well. With regards to the computer used to commit a crime, there is an allegation that with regards to the CashApp accounts, that has already been explained and discussed by the court, that it was used to commit a crime for that purpose. There's enough evidence there. There was a stipulation for count 5, weapons found in possession, and the other felony firearm counts that are associated with those counts. There has been enough evidence to go to trial on all of those charges. Yes, there is a circumstantial case. The court does really appreciate the arguments made by Ms. Krause. It is a circumstantial case. As both parties are aware, circumstantial evidence can be used at a trial. And I also want to indicate this is a preliminary examination. This is a motion to quash. These are allegations at this time, and but the motion to quash, based on the case law, based on the facts of this case that were presented to the court, this court cannot say that there was a abuse of discretion by the district court magistrate in binding the defendant over on these charges. So we, as previously stated, will be here on December 5th for any issues that need to be brought to the court's attention. I've already indicated that would be any type of plea cutoff date will be that day, and anything else from either side.
Can we get a specific time for December 5th?
I would like to do this first thing in the morning if that works for everyone.
That works.
I can try to be here maybe 8:45, even 8:30. What's the earliest? We can do.
8:30 is good. Yeah.
Does that work? Can we be here at 8:30 on December 5th?
Yes, Your Honor.
Okay. So we will be here at 8:30 on December 5th. Anything else from either side?
Not at this time, Judge.
I'd rather be the judge. Thank you.
Thank you, everyone.
Enjoy more of our videos on the Community Advocate Network channel, and don't forget to like, share, and subscribe. If you would like to advertise your service, special announcement, or event, you may contact us at the Community Advocate Network at gmail.com. For community resources or services, visit our website at www.canmichigan.com.